All right. And how does the Law Society, which is made up of lawyers, advocates, recognize the mediators within the same space?
Let me first answer the first question before we go into the second question. I think it's important to understand the philosophy of law. It is true that human beings have disputes all the time. And some of the disputes are informal disputes. You have disputes as you're interacting with other people, and you need relationships to be built. And the majority of the disputes, people engage in various dispute resolution strategies. Sometimes it's avoidance. They just avoid the dispute or ignore the dispute. Sometimes it's confrontation. Sometimes it's negotiation. We have disputes as friends. We have disputes as business partners, etc. So a moment comes when the dispute becomes something that is connected to the law. So what is the law? The law is the framework that we have established for how we shall arrange our affairs together. It has the rights, the wrongs, the duties, the responsibilities that we all have with one another. So majority of the disputes become formalized when the significance grows and the law comes in. So it's not possible, once a dispute has become formalized, to resolve the dispute outside the law. Even alternative dispute resolution is resolved within the framework of the law, because you need to know the rights and obligations of the parties. For example, you can't resolve a parental dispute by both parents agreeing none of us will take care of the child, because Article 53 of the Constitution gives you a responsibility as the father and the mother, joint responsibility to take care of the child. So the Constitution applies in matters of dispute resolution regardless of the nature of the dispute. The criminal laws apply. So you cannot resolve a dispute by agreeing to commit a criminal offense, for example. So the law applies whether you are resolving the dispute in the court or outside the court. So the role of the lawyer is always central once there is a dispute that touches on matters of the law. And the central provision of the Constitution touching on how we shall resolve disputes is actually Article 50, sub-Article 1 of the Constitution. And what it says is that every person has the right to have any dispute that can be resolved by the application of law. You remember what I said, application of law. To be decided in a fair and public hearing before a court. So you have a right to go to court, or, if appropriate, another independent and impartial tribunal or body. So the right to be heard in a fair way, apply the law, the Constitution, that one is central to all dispute resolution processes. So what happens when you go to the court is you go before someone who has been trained both in law and in evaluation of facts. You can't become an officer of the court, a magistrate or a judge, before being trained in all that, because you have to evaluate both the facts and the law and make a decision. That is the evaluative kind of dispute resolution. Then alternative dispute resolution is of two kinds. There is evaluative and facilitative. So the evaluative is like arbitration, where instead of going to a judge, you go to an arbitrator who still evaluates as a neutral third party what are the law and the facts of the case and decide the case accordingly. Or you can go to a facilitative dispute resolution mechanism where the parties become the principals in negotiating amongst themselves, and a third party comes to assist them in the negotiation. Even when you do the facilitative process, you still need to pay regard to the facts and the law, even as you are compromising, as you are agreeing, because the law is what we have agreed will govern our lives together. It is the framework that applies. So in answer to the question, what is the difference between lawyers and mediators? First of all, in many countries, majority of mediators are lawyers, for the simple reason that the lawyers are already trained in the law. and they are trained in evaluation of the facts, and they're also very good in facilitating agreement between the parties.
Okay.
But you can't just have lawyers in alternative dispute resolution. So in arbitration, for example, you have other professionals who already are expert in their profession, and then they are trained to understand aspects of the law and of dispute resolution. Mm-hmm. So the same thing happens with mediation, or ought to happen with mediation. So what the lawyers have been saying is that that is the ideal. Mm-hmm. But over the course of the last 10 years, as we have been implementing mediation, court-annexed mediation, people have already gone to court. There is a clear legal question. There is a factual question to be determined. The process of facilitation through court-annexed mediation is now broken. It is now suffering, it's leaking, it's suffering significant injury because of the way of implementation, which is what we want to talk about. So we want to make it clear that when you say LSK versus mediators, it gives the impression that lawyers are not mediators. Actually, lawyers are the first and foremost mediators.
Okay.
But they are joined by other professionals who may also come to do mediation in accordance with the approach that the lawyers have formulated and have practiced.